Okay, folks, let's get started. We think about prosecutors as government officials. In fact, they're the embodiment of executive power. And yet prosecutors in the private sector were the norm in this country. That is, if you're the victim of a crime or of an alleged crime, you go and you hire yourself a lawyer in private practice, who will then bring the charge in the name of the state, but operating for you, the person paying the bills. We moved away from this system starting in the middle of the 19th century and moving decisively in that direction by the last half of the 19th century, so that now we give exclusive authority over the filing of criminal charges to a public official, the prosecutor. They are acting as a government official, acting in the name of all the people. This question of private prosecution is worth our time now, just for a moment, not because this is something that practicing lawyers spend a lot of their time thinking about in their day-to-day activities at the courthouse, but it's worth stopping and taking a look back and asking what this historical development shows us about the nature of the prosecutor's role, and in particular, the relationship between the prosecutor and the victims of alleged crimes. So let's jump in and take a look at a relatively recent case that raises these questions pretty nicely. Now, in State versus Culbreth, we have a private organization called the Citizens for Community Values, or CCV. This is a group that's concerned about the sale and display of obscenity in Shelby County, Tennessee. And so they arrange to hire an attorney. They hire this private attorney, Larry Parrish. He's a former federal prosecutor, former AUSA, and they hire him to go work with the state district attorney for Shelby County, Pierotti, to develop obscenity cases. So Parrish takes the job. He meets daily with two assistant district attorneys from the Shelby County office. He meets with state investigators, some paid by the district attorney's office, some who work for the Tennessee Bureau of Investigation, the TBI, some who work for the Department of Revenue. But Parrish's salary is paid by the CCV. He's paid an hourly rate to work on these cases. And later on, the CCV also pays for some of the expenses of the investigation, not just his time. Along the way, Parrish develops some viable cases. So Pierotti appoints Parrish as a special assistant district attorney. Parrish files some civil nuisance suits against some sexually oriented businesses. A new DA comes into office, William Gibbons, and he continues to work with Parrish and now is willing to indict Culbreth for a criminal charge for promoting prostitution and public indecency. All told, Parrish received over $400,000 over 19 months worth of work. So at trial, the defendant says, before we even get started here, we have a problem. And the problem here is that the prosecutor here has a conflict of interest and is not the sort of balanced public official that we can expect in criminal matters. The judge hears this motion, finds that Parrish had received some, quote, enormous compensation from private groups, and the judge concludes that that created a conflict of interest, and so that required Parrish's disqualification as the prosecutor in the case. And along the way, the judge says this also disqualifies the entire Shelby County District Attorney's Office because of the substantial role of Parrish in this prosecution. It tainted the entire office because they worked so closely with him along the way. So if this case is going to go forward, it's going to have to be prosecuted by some state prosecutor who's brought in from outside of Shelby County. There's an appeal, and the Tennessee Supreme Court affirms the trial court's disqualification of both Parrish and the office and dismisses these charges because the court says the prosecutor had a conflict of interest that amounted to a due process violation. This was just so far out of the prosecutor's role that we can't have fair proceedings with a prosecutor acting like this. Well, the court here gives us some of the classic case law descriptions of what a prosecutor is supposed to do. So, of course, they quote from Berger versus United States from 1935, a favorite older case on this topic, where the court says that it's the that the prosecutor's interest is not that it shall win a case, but that justice shall be done. And then in another famous turn of phrase here, while the prosecutor may strike hard blows, a prosecutor is not at liberty to strike foul ones. The Tennessee court also quotes an old Tennessee case and the ethics rules of Tennessee that say that the prosecutor's duty is to seek justice, not merely to convict. This is plastered up on the wall in lots of prosecutors' offices. It's a basic of the prosecutor's role. We're not here to win cases, we're here to do justice. And the rules go on to say that a prosecutor should use restraint because, interestingly, a prosecutor is making not just the normal choices that a lawyer makes when you're representing a client, but you combine the choices of the lawyer about how best to obtain the client's objectives, the means questions that lawyers normally decide. Prosecutor not only decides those lawyerly means questions, but the prosecutor also decides the ends questions that normally are left to a client. So that combination of power makes restraint especially important for the criminal prosecutor. So who is the prosecutor's client? Well, the client is the entire public, all of the voters of Shelby County in this case. The client is not the victim of the alleged crime, not the complaining witness. That's not to say that prosecutors don't care about victims, that they don't do their best to make the experience as acceptable as possible for victims, to treat them with real respect and compassion. They are very important people, and they have a different kind of stake in the outcome of this criminal case than the normal run-of-the-mill voter. That being said, the attorney-client relationship runs between the entire public and the prosecutor. And this means that ultimately the prosecutor might say to a complaining witness, sorry, we're not going forward with this. Ultimately, the victim of the alleged crime doesn't control the objectives of the representation. It is ultimately the prosecutor's call how this is going to happen. Now, how is Parrish different from this normal arrangement? Well, Parrish is paid by the hour by a private group who really want to see prosecutions here. In terms of incentives, Parrish is probably listening more to this set of victims than the typical public official prosecutor would. At least that's the view of the Tennessee court. Now, the Tennessee court treats this as a conflict of interest, and it refers to the ethics rules under Tennessee law to explain the nature of this conflict. If we were to frame this in terms of the current model rules of professional conduct, not the older Tennessee version, we would not say that there's a conflict here between one client and another client. It's not what we'd call a concurrent client conflict. It's not client versus client. Instead, it's the real client, that is the entire public, versus somebody who's not a client, somebody who's paying. In legal ethics, we would call this a third-party payer situation. And in these situations, maybe somebody other than the client pays the bill for a private attorney, but under the rules, you always have to remember that the third-party payer is not the client, and you have to tell the client, I'm receiving money from that other source, but don't worry, you're the client. I'm going to let you control what happens here. Something similar is supposed to go on with prosecutors. That is, they're not supposed to be listening to the main interested person, the victim of the crime, or here the party that's paying for the position in the office. Instead, prosecutors are supposed to listen to the client, meaning the views of the entire community about what their priorities should be for criminal justice, what they want the prosecutor to emphasize or not to emphasize in applying the very broad provisions of the criminal law that leave so much discretion for prosecutors. One final question to think about, and that is, what does the prosecutor do with those complaints that come in from the public that are not filed on the basis of police reports? Somebody just comes in and says, my neighbor cut down a tree on my property. My neighbor, hit me. So there's some kind of
squabble between people, and it could form the basis for criminal charges. Should the prosecutor just stand back and say, get down to the courthouse, file it, and I'm not involved here? Or should the prosecutor take a more active role in screening and dismissing some of these charges? In some places, there are special days of court assigned to these, sometimes called private warrants. The days have entertaining names like Friends and Family Day. But it raises an interesting question of how the prosecutor either does or doesn't assert control over these private claims for criminal law enforcement. We'll talk about that when we get together next time.